Alex here with part 8 of the My Docket series on child custody and visitation. This is going to be the first video in the series that covers a hearing. I am back on the defensive. This hearing is the one that will determine whether or not the extended protection order is issued. All it is taking a temporary protection order, giving it more time, and just like that it's turned into an extended protection order. There is some statutory criteria that the court needs to abide by, but it is very lax. The hearing is an evidentiary hearing, which means the court will be reviewing evidence, hearing the testimony of witnesses, making findings of fact and conclusions of law. It's going to be hopefully an educational video for my viewers. I am going to cut in at several points and explain things that are going on. It's not going to be so much me cutting in to refute my ex's statements. I don't really need to do that because, oh, I haven't even mentioned my disclaimers. Going into my disclaimers really quickly, please watch part 0 of this series, the My Docket series. That is the video that contains the detailed explanation as to what the purpose is of this series and, of course, the other disclaimers. The first and most important of which I will state now, my case is completely and totally closed. My ex's parental rights have been terminated. The second is that this is supposed to be one big gigantic example for my viewers, so I'm providing this video and of course my explanations as to what's going on during the hearing as a way to show both an example as to what I went through personally and how I handled it, and also a little bit of an educational process in explaining what's going on, what I was thinking, why I could have done this, could have done that, should have done this, should have done that. That'll be the point of this video. So, if you do want to see the whole video, because portions of it are going to be skipped over, the portions that I really don't think I can provide as much value to the viewers on. If you want to see the full video, you can just go down into the description below and click on the link. It will take you to an unlisted video on my channel, which is just the entire hearing video, uninterrupted, beginning to end. Nothing has been cut out of that video. And if you have questions specific to what I have not covered in this video, please post those questions as comments in the unlisted video and I'll get back to you to the best of my ability. You will notice a couple of things in that video that I'm just going to skip over this video because the judge doesn't really make any determination based on it. The first is that my ex blames me for trying to kill herself, so that's one part of the unlisted video that I won't cover. And again, it's just because the judge didn't really talk about it. The judge didn't address it. The second is the way that my ex uses the phrase, they told me, she told me. It's something that I want people to know about as a yellow flag for personality disordered individuals or severely emotionally immature individuals. If you see that in your own case, that your ex is claiming to the court that they only did certain things because other people told them to do them, that stands out as the alarm bell should go off. That is something that I see consistent with a lot of these cases, a lot of people who contact me. There are situations that are very similar to mine where their ex is trying to justify their conduct, as bad as it may be, by claiming that other people told them that's how it was supposed to be or told them that that's what they should do. It's not really as much in this video as you'll see it come up in some of the other videos, but it does come up enough that I wanted to tell my viewers to look out for that because I'm not going to cover it throughout the video when I'm stopping and starting. I'm going to try to focus more on some of the legal nuts and bolts that are moving around in the background and just things along that nature. It's not going to be really an opportunity for me to refute each and everything that my ex has done because her parental rights have already been terminated. I don't need people to believe me. This case is over, and it very clearly went in my favor. So, last thing I wanted to say before I start is please understand that I do not agree with my explanations. When I make explanations as to what's going on, it doesn't mean that I think that's the right way that it should be working. It doesn't mean that I endorse the system. I'm just explaining the way it works, as dysfunctional as it is. And hopefully my advice helps people work around the dysfunction. And hopefully people don't take it as, oh, Alex likes the system. No, I don't like the system. I'm just explaining it. And there are certain areas where I have to explain certain things that do not sound good. But that's just how they work, as bad as they are. And hopefully someday in the future enough of the population figures this out and makes some changes. But for now, we are working in a system that has little to no oversight, at least with regards to the masses, the voters, the citizens. So that being said, let's jump into the hearing.
Good morning, Your Honor. Kathrine Berning on behalf of Ms. Farrar.
Good morning.
Case number FD 0803338, Monica Farrar versus Alexander Falcone.
This is the time and place set for two matters to decide if the order of protection issued on the 8th should be extended based on an application of the 5th. I have no record of service. Oh, yes, I do. I see it over here on the side. Our clerk tells me that Mr. Falcone was served on October 6th.
So what the court is doing here is determining whether or not it has personal jurisdiction over me. Automatically, by filing the petition, my ex has submitted herself to the jurisdiction of the court. But jurisdiction over me, the adverse party, isn't automatic. It doesn't occur until the court has verified that I've been served consistent with the law or the court rules.
And the applicant was served with a... Can we check that? That doesn't make any sense.
I'm looking at the repository. 9/16.
Which one?
Falcone was served on 9/16, and Monica was served on
All right. That makes more sense. It looks like Mr. Falcone was served on September 16th, and the contest motion filed on the 17th by order of the 29th was served on Ms. Farrar on October 1st.
The contest motion that they are referring to is the motion that I filed after having been served with the petition, and that motion is the motion to dissolve the order of protection.
Can somebody tell me the status of the custody case?
She's got all the custody.
Your Honor, if I may, we'll be filing a opposition to Mr. Falcone's petition. But I would tell the court right now that I think that we have, at least in the interim, the stipulation between the parties for the parties to go to mediation, and also interim visitation schedule that we wish to implement as far as Army, the child of Mr. Falcone and Ms. Farrar.
So when one person doesn't have an attorney, as in this case I don't, typically the judge will focus on the attorney first, especially when it comes to catching up as to the relevant factual and procedural background, which is what the judge is trying to do here. The judge is going to assume that if you're a non-attorney, you don't know what's going on, and they will take advantage of the fact that somebody does have an attorney to immediately address them and get those pertinent details that I mentioned earlier. So this is something that you should prepare yourself if you're unrepresented, and just be okay with not being able to speak first, and understand that you'll get the opportunity to clarify or counter whatever factual assertions your opponent's attorney is making. It's going to come, and try to be patient and hang in there.
So is there an interim order in place? Will both of you please stand, raise your right hands?
So most people have seen this in the movies or on Judge Judy. The swearing-in process is essential when a court is going to make findings of fact based on the testimony of witnesses. You are not in Hollywood, so you may find yourself at certain hearings where nobody is sworn in. And that is because in those particular hearings, the court isn't going to be making any determination or any factual findings based on the testimony of any witnesses. A lot of times in these child custody situations, the only witnesses are the parties. So sometimes people are confused and they are like, what are you talking about? What witnesses? You, a party to the action, are a witness. And when it comes to divorce actions and child custody actions, it's quite normal for the only witness to be you for yourself and your ex on behalf of herself. The other thing that I wanted to mention here is, some people have told me, why aren't attorneys sworn in? They can lie too. Attorneys are not witnesses. Just because they are saying things doesn't mean they are testifying in support of their client. What they are doing is they are arguing their case. The court will understand that if the court needs to make findings of fact and conclusions of law, the court will understand that these attorneys are just making arguments and that it will need to allow the witnesses to testify to determine whether or not the court finds that to be true. And in fact, the Supreme Court of Nevada has slapped down certain decisions rendered by certain judges when the judge uses the arguments of the attorney to support their orders. The Supreme Court of Nevada has stated that the arguments of counsel are not evidence because they're not testifying. They're not sworn in. They're not a witness to the case. All they're doing is arguing as to why their client should win the case. And it is very important for a judge to understand that those arguments are not testimony. And if it's not testimony, it cannot be used as evidence to support the court's decision. There are some other oddball situations where decisions are made on a prima facie case, which is typically, I mean, I can't understand in any other situation where this wouldn't be typically, but typically or possibly always, the decisions in those situations are temporary orders. A temporary type of let's hold things over for now until we actually get to trial or the evidentiary hearing, and when that occurs we can actually take in evidence and determine whether or not any of this stuff is true. So that does frustrate people as well, because sometimes the court will enter a temporary order that is not supported by findings of fact, and that's just something that they could do on a temporary basis until they get to the hearing. We can talk more about that when it becomes a little bit more relevant, but I did want to let people know that there's a lot to the swearing-in process. There's reasons as to why this occurs. It's not just one of those things that everyone does, like tying their shoe when they put it on in the morning. It's just a routine thing. It matters. There's a reason behind it.
You solemnly swear that the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Please be seated. You are Monica Farrar, and you are Alexander Falcone. And Mr. Falcone, have you had an opportunity to read the documents served on you?
Yes.
All right. And Ms. Farrar, you've had an opportunity to read the documents served on you. And are you still pursuing an extension of the protection order?
Yes.
And you're still seeking to have it dissolved?
Yes.
So what the court is doing here is trying to be as efficient as possible. Oftentimes people will come to court and somebody will have changed their mind. And when that occurs, the court needs to stop the proceedings and render a decision based on whoever it was that changed their mind. So for example, the applicant may come in and say, I changed my mind, I don't want this order anymore. The adverse party may come in and say, I changed my mind, I don't want to try to dissolve it, let's just set it and let me get out of here. And so that's what the judge was doing, and that does save a lot of time when it ends up being the case. And so in this particular case, neither one of us is going to back down, and so the proceedings will go on.
This should be heard in the first place. And I'm wondering if it would benefit you to have this heard by Judge Weller.
So the domestic master here is doing the absolute correct thing. This domestic master recognizes that a child custody action was instituted and that these issues will ultimately need to be reviewed by that presiding family judge, which in this case is Charles, also known as Chuck Weller. And I should have agreed to this. Whenever possible, you should have these types of issues consolidated, and you should have the presiding, duly elected family judge making the determinations and orders on these types of issues. Domestic masters, they just don't have the experience. They're unelected, they're hired, and they also don't have as much time. And this domestic master is admitting it. And she's admitting that this is going to be something that Chuck Weller would be better suited to make a decision on. I had no idea why this mattered. I just thought a judge was a judge and they were all the same. I assumed that when you go into court, everyone gets the same decision based on the same facts. And it is absolutely not true. It's not the case. And in hindsight, I am confident that Chuck Weller would have denied my ex's request to extend this order of protection. And the reasons for it is because when she brings these issues up in his court, he dismisses them. He actually listens to the controversy, or he listens to my testimony, which controverts my ex's testimony, and he does come to the conclusion that she's really not in any danger. But for reasons that I'll discuss later on in this video, the outcome ends up being slightly different. It's not that this judge completely believes my ex and extends it for the full year, but she does extend it for 3 months, and I have some sort of ideas as to why she decided to do that, but I want to wait for that to actually occur before I cover it. The last thing that I wanted to mention is that had I allowed this to instead be put before Chuck Weller, it's likely that my ex would never have sought the fictitious address from the confidential address program. And it's likely that I would not have published under Falcone v. Secretary of State because I would have had no basis to challenge that. And it's possible that today there would be no procedure in place for a person who's been falsely accused to challenge their ex's confidential address. So on the one hand, it's frustrating that I made the wrong decision and it did impact my case. But on the other hand, it was something that led to my publication in the Supreme Court of Nevada. It was something that created a doorway for other parents after me to challenge their ex's use of the confidential address program. And I have to admit, it's possible that my ex would still have some kind of visitation rights today had this judge not made the decision that she did. This domestic master makes the fatal decision that causes my ex to cling to this idea that she's a victim and she won't release it. That absolutely and without question is what led to the termination of her parental rights 8 years, well, yeah, about 8 years later. So it's interesting how sometimes a mistake can actually cause more damage to your opponent's case, especially if they have mental health issues or personality disordered issues, because they will often not understand how reality is actually functioning, and they will sometimes take a victory like this and run with it in a direction that goes much too far. It would have been better if they had tempered her from the beginning. She may have not continued to refuse to disclose her address for so many years, and to today she may have still had rights, visitation rights to see, our son. But that's not how it worked out. This judge does ultimately give her 3 months, and that is the first domino in a long series of chain reactions that ultimately does lead to the termination of her parental rights.
Your Honor, we'd be willing to have it heard by Judge Weller.
I don't. All of the stuff that she put in there was lies, and I don't think it's a good idea. I mean, I was hoping I could get it resolved as soon as possible. I submitted 2 police reports showing evidence that they told her about how to file a TPO in April, and she waits 5 months later to do it just because I filed a suit.
What I'm trying to do is figure out what to do procedurally.
Okay.
I know Ms. Berning quite well, and I just want you to understand that. Do you have any problem with me hearing it?
I don't.
All right. Okay.
So what the judge is doing here, and this is interesting because my ex's attorney is actually agreeing with the domestic master. I don't think it's that she has the insight to know where this case is going to go. I really don't. I just think that she, like many attorneys, likes to do whatever the judges suggest. From what I have seen, most of these family attorneys will put the law second to the judge's wishes. If the judge wants to do something, most of these family attorneys will just go along with it. This is not something that occurs in other types of cases. Multi-million-dollar punitive damage lawsuits, medical malpractice lawsuits, stuff like that. No, the attorneys will tell the judge what they want, whether the judge likes it or not. But in family law cases, it's quite different. It's like these attorneys all want to be friends with the judge, and there's this idea that things will go, better for them if they are seen as an attorney who goes along with whatever they suggest. And I think that is most likely what is motivating her attorney to put it in Weller's department. I do think that had this gone before Weller, I do think that he would have denied. the request to extend the order of protection. I strongly believe that. And so her client would have a worse outcome by going along with her attorney's suggestion, at least with the perspective of winning this petition. You know, in the, you know, looking into the future as to how things would have turned out differently, it would have been better had her attorney gotten her way. But that's only because my ex's ability to perceive what is going on is too easily warped, and it gets worse when she perceives a victory in court. When she perceives a loss, in a way, it does anger her, and she does want revenge, but in a way, it sort of tempers her actions. Whereas when she wins, it causes her to kind of get out of control. She kind of takes it and runs with it way, way too far. So in the context of winning this petition, it is better that that my request is granted, because she will end up winning this petition in front of this master. But in the context of still having some kind of parental rights in the future, 8 years later, it would have been much better for her to have had this petition denied straight away. And the other thing I wanted to mention is this master admits to knowing that attorney very well. This is a concern. If a master or a judge has to say that on the bench, on the record, it's a big hint that they may not be able to really set aside their personal opinions as to what they think of that attorney in the case. This is not normal. However, I don't know this at this time. This is the first time I've been in front of a domestic master dealing with the child custody issues. In fact, this is the first time in my life that I've been in a courtroom. So I had no idea the ramifications as to what this master was saying. And I was so obsessed with ending this now that I could not see beyond the day of the hearing. I had myself convinced that I would win and that the order would be denied, because I was going to expose the contradictions in what she, stated in writing. And you will see that I do expose these contradictions. I do raise questions that cause doubt. But what I failed to understand at that point in time is that you can't trust the judges to be logical. You cannot trust them to do this. It is especially going to be a concern with the smaller judges. So when you're talking domestic masters, judges pro tempore, these ones are less likely to really put as much thought, and it's as though they aren't scrutinized as much, so they don't feel as though it really matters even if they're wrong. It's this kind of idea that, well, if I'm wrong, who cares? And so you don't really have that as much with a judge who's been presiding over an actual department, with a judge who's been elected, who has a lot more experience. And I really didn't understand any of this. So I just was thinking to myself, this has to end now or I'm going to go crazy. And that's consistent with everything I'm doing in my case, because my ex is filing things and I'm responding a day later. So, and this is happening on multiple occasions. So it's obvious that for me, I want a decision now, and I do not care. I'm not thinking carefully. I'm not understanding how the system works. I'm just focusing on what I want and my feelings. I'm not thinking as to how the judge's desires and wants and feelings are going to matter. In fact, a whole lot more than mine, because they're the one that's going to make the decision. So I would have had to wait a couple of months to actually get this in front of Judge Weller, or maybe I wouldn't have. Maybe this would have triggered some kind of hearing immediately within a week or two. I didn't know this, and it would have been worth the wait. So for anyone out there, if you're going to a hearing in front of a domestic master or some kind of magistrate, some unelected hired mini judge, and they tell you, you know what, I think maybe this should go before the actual judge in your child custody or divorce action, take it. Do that, because you're just going to have a better shot, especially if you're the one falsely accused, because they're less likely to err on the side of caution and play it safe. And if you have to wait a few days or a couple of weeks or even a couple of months, you should still do it, because you want to get the best quality analysis of your particular situation. You don't want one of these really quick and dirty turn and burn style judges who just show up. This is a substitute judge. She just showed up today. This isn't even the judge that ran the department. There is no department for handling orders of protection. And so these judges, they're not really attached to these cases. They just show up to work, and you'll get a random judge at one hearing and a random judge on the other. And again, they're not even judges, they're hearing masters. And so it's just overwhelmingly favorable to the falsely accused to get the best quality analysis possible, because that is going to make it so that you're less likely to have that situation where the presiding judge decides, oh, well, let's just err on the side of caution. Who cares if she's lying, and let's just grant it anyway.
And that really wasn't the basis for my suggestion. It's just that Judge Weller is already deeply involved in this. I know there's quite a lot going on in that case.
Oh, yeah.
All right.
Your Honor, if I may, with regard to the stipulation that the parties wanted to enter in this court regarding the visitation, it would be in the line of modifying the TPO to allow contact with for Mr. Falcone to have contact with his child, and that's why we were talking about
Okay.
the visitation.
That's fine. And anything, if we do extend the order, what we would do is conform it as much as we can to whatever agreement you've already made, if it comes to that. All right. Let me hear from you, Ms. Farrar. How long are you seeking an extension for?
A year.
All right. Counsel, you want to ask her some questions?
Yes, Your Honor, I do.
So here, my ex's attorney is going to set the record in a way that will give the judge or the domestic master the basis to grant the relief that is being requested. There are certain things that have to be alleged for the domestic master to have the authority to grant this extension. And typically it is two things. I don't know how other states work, but in Nevada, one of two things have to be shown. One is that actual domestic violence has occurred. That's what typically actual victims are going to lead off with. The other, and this is for all of the other people that have not been victimized by domestic violence but still want an order of protection, the other, and this is the one my ex is going to assert, is that domestic violence might possibly occur. And so she does kind of try to allege that she's been subjected to violence, but she at the same time hedges. I've talked about this in previous videos. She creates those little paths of retreat just in case. She says things like, might have this, maybe that. Don't, you know, it's like she's not really confident in what she's alleging, but she's kind of focusing on how she felt, on how my purported statements made her feel that something might happen. And this is kind of what I call double speak. It's a way for them to make allegations whilst at the same time, if they are confronted on them, be able to retreat. It's not like she's making allegations that are decisive, risky allegations that if proven wrong would be considered a bald-faced lie. So I've talked about this in previous videos. This is what she does. And I'm going to actually skip a big part of this because I'd rather focus on the part where she's getting questions as to what she's alleged. And so you're going to see me skip to that in a second. And then the responses to my questions are going to be a lot more educational to the viewers than the monologue that's about to follow this right here.
In April.
In April.
Okay. She's going to have to speak up. Both of you, there are little microphones in front of you, and I sometimes can't pick up really soft voices, so... Mr. Falcone, do you have any questions you would like me to direct to her? Questions, not argument. You're going to have an opportunity for that.
So this is the absolute most crucial part of hearing like this, and I actually did a good job. I did ask relevant questions, and what I was focused on was exposing contradictions. If your ex is a liar, they are going to make statements that aren't consistent with their actions, and that is what you have to focus on when you have the opportunity to question your opponent. Also take notice that the judge said this is an opportunity to argue. This is because a lot of people who represent themselves just try to argue. So they don't try to ask the other witness questions. What they'll try to do is just say, this is a lie, this is a lie, this isn't true, this is a lie, this is what I'm trying to do, and I should win because of this. And that's, you're just arguing. You're not using the question and answer process the way you're supposed to use it in court. So again, as I mentioned, I did do, in my opinion, a great job on asking questions that would expose contradictions. And I am going to play this part of the hearing because I really want my viewers to soak this in, because this is what you have to focus on once you have the opportunity to ask questions, is to ask the questions that will expose contradictions in what your opponent has alleged and in what your opponent has actually done.
Okay. The first question would be, had I ever gone to her workplace or ever tried to find her, like, before the attempt to service her?
Before which time?
At any other time, basically I'm asking her
Oh, okay.
if there's any other time besides when she was...
Other than the times that he was attempting to serve you, had he ever come to your work?
I don't think so. I don't know. There was a couple times when I thought I was being followed and I would take different ways home, but I can't say for sure that he
All
was
right.
there.
Next question.
The first time I sent a service processor to serve her with the documents...
Hey, what's the
The
question?
question is, how come if she didn't want to be harassed at work, why didn't she just accept the documents from the service processor?
Because it's federal property, and I already knew that he'd filed in court, and I talked to the police department, and they said nobody's allowed on federal property without prior permission from the VA police, and that for serving paperwork, you have to go to HR, the police get called over, then I get called over, and they serve you. And I emailed him that, and they explained that to the gentleman, or whoever it was, his friend or whoever, because he wasn't dressed professionally according to my coworkers. They didn't believe that he was an actual service processor. They thought he was a friend, a mechanic or something. But I mean, it's federal property. You're supposed to follow procedure. And I didn't actually see the guy. I was on break, and my coworker called me and said they escorted him to the police office.
All right, next question.
I still can't believe my ability to focus on certain portions of the proceedings that are crucial and make big mistakes on other areas. And I think the big mistakes are on my sense of urgency, on my sense of wanting this to get resolved quickly. But in the way that I handled this question, as soon as I got the, quite frankly, bogus response from my ex, I moved on to the next question. A lot of self-represented parties will try to argue with that response. It'll be something like, well, you didn't have to, insist that I follow those procedures. You could have just gotten the papers, or you could have come down to the HR office. It was a perfectly safe, neutral area. But I didn't argue. I moved straight on to the next question. By the way, there are some statements she makes there that aren't true. Something about emailing me the procedure as to what I was, that's not true. She never did that. She didn't respond at all. And I had to kind of figure out what it was going to take for her to, accept the papers. When I went back, I think for the third time with the process server, that's when they were frustrated. They were like, what? She still hasn't gotten these papers yet? And they forced her to come down. So they didn't act like they knew what was going on or like this was all scheduled or planned. They were like pissed off because they were sick of her using her workplace as a hide-and-go-seek. There's also opportunities here that I really missed out on. For example, I could have raised this in discovery later on in the child custody action and forced her to produce the rules, because she's alleging that there's these federal rules as to how you're supposed to serve somebody on federal property. But to my knowledge, this isn't a thing. If anyone out there happens to know what she's talking about, definitely post it in the comments below. But there isn't any federal rule system in place as to how you serve employees who work on federal property. I feel like she probably pulled one of those sovereign citizen stunts and drew some kind of language out of some inapplicable or out of context statutory scheme. And I really should have pushed this issue later on in the child custody action. It's important that you do these things, and I just overlooked something like this. It's important that you take advantage of these kinds of statements because they do fall under the best interest factors if you can show that they were a lie. If you can show that under the best interest factors, your ex is not the parent most likely to facilitate contact with the non-custodial parent because she is dragging out the proceedings, refusing to allow you time with the child, and you could even show that she's just invented these rules out of thin air and that they don't exist, or you could even say, who was it that told you? What employee, what police officer told you this? Because once you get the name, you could subpoena them and have them commanded to appear in court. And most likely that officer or that staff member or whoever it was that told her that would say, I never told her anything like this at all. And in fact, it was very likely that had I made that request, she would have said she forgot who it was. There are a lot of opportunities in this video and in this order of protection action that really slipped through my fingers because I just settled the case later on. But having seen this video, there are several things that jump out at me that I really should have, and I think it's because I just wanted joint physical custody. And as soon as my child custody judge told her, these mental health records are going to impact my decision, and she panicked and backstepped and said you can have joint physical custody, I just gave in because that's what I wanted originally. That was my original request. And there's just a lot of regret here because I had a substantial case for primary physical custody, and I just didn't know it because I was afraid of the court system. I wanted it to end, and I got what I asked for, and I really should have thought this through. If I had the experience then that I have now, I know exactly what I would have done because there were absolutely opportunities here that I could have taken advantage of to show that she was lying in ways that would have connected, in ways that would have resonated with Judge Weller, ways that may not have resonated with this temporary judge or sit-in, but ways that would have impacted Judge Weller's decision. And I could have potentially gotten primary physical custody had I showed, had I shown that she lied in these situations. So anyway, let's move on.
What time does the VA HR close?
The HR closes at 4:30,
What time does she start work?
3:30, which I notified him of.
Okay,
in email.
3:30 is the answer.
This is a great couple of questions that I just asked. A lot of times your opponent will state something to the court in a way that makes it seem a certain way. And what my ex and her attorney were doing was they were making it seem as though there was this amazing opportunity available for me to have my ex served. And that would have been the HR that I could just go and sit there and wait. But the problem is that she has a swing shift. And so when she starts work, HR closes shortly thereafter. The window of time here is very narrow. And I wish I could remember, I really can't, but I imagine that I had tried to serve her during that short window of time on a couple of occasions. And for whatever reason, she didn't come down, and HR had to close. So what I was trying to do was show the court, you know what, this isn't so simple as she makes it seem. This window of time, this opportunity is a lot more narrow than the court is aware of. And I didn't even have to explain that. I just asked 2 questions, boom, boom, got 2 answers, boom, boom, and I moved on. And you can see here that because she tries to explain to the judge, my ex is concerned that I'm trying to make it seem as though she didn't tell me something. And so she's not understanding how this legal process works, and so she tries to explain herself, but the judge just cuts her off and says, okay, the question's answered, move on. It's enough for me to put these statements on the record. I don't need to argue with her and go back and forth. I just need to ask questions, get the answers that I need, and move on. Because I'm going to use her answers later on, towards the end, when I get to present my oral argument. So definitely keep all of this in mind, and take note that I am still either exposing contradictions or making clarifications for the court, and I am doing so in a question and answer format.
Next question.
When she called the police, did the police not tell her how to file a TPO? The second time the police showed up and she called them on me.
Let's try that again.
When the police showed up, the time that she says I threw her out and all that stuff and locked her outside, did the police not tell her how to file a TPO?
Did the police tell you how to go about seeking a protection order at that time?
Yeah, and I went down there to try and file it.
All right. Next question.
Did she have any problem coming back inside when I, quote, threw her outside?
Yeah, he slammed me in the door over and over again and told me later the only reason why he let me back in and stopped was because I was screaming and that he couldn't get my screams out of his head.
Next question.
When my position was eliminated at work, did I not stay home and take care of my son for 6 months as a stay-at-home dad?
Well, and you went back to school as a student that I paid for.
When Monica was going, when you were...
Wait a minute,
Oh,
let's
sorry.
not argue. The question was, did he or did he not stay at home with your son for 6 months and be a full-time dad? Yes or no?
Yes.
So even though she has counsel, she's making the mistake that many people without counsel make. She's trying to argue. I asked a simple question, I expect a simple answer. A lot of times it also seems that she is treating the question and answer format as if me asking questions of things that I don't know about, and so she's either trying to explain them. This comes up later on too. She's either trying to explain to the court that I already know these things, or she's trying to argue as to why she did a certain thing when I really just need her to state to answer the question. I need her response on the record. It doesn't matter if I already know the answer. I need to get that answer put into the record. I need the judge to hear it.
Okay.
At the times that I was staying home and taking care of my son, did I not change many more diapers than you, feed him many more times than you, and also get up at night when he was crying and get him at least as many times as you?
Objection calls for speculation. This witness would not know what occurred when she was working.
How would she know that?
We were doing spreadsheets where we listed all of the food that we were feeding him because he was having trouble gaining weight, and that was my responsibility, and I filled it in the spreadsheet so she'd know how much I fed him.
Can I answer?
No.
You know, that's interesting, and I'm glad you were doing that because that's a great health record. My problem with all of this is it's getting a little far afield. If we need to decide custody and visitation, we can get
Yeah,
into
you're
that
right.
sort of thing.
We're just talking
So
about
I'm
the
really,
PTO.
I really want to focus more on the protection order. I mean, I've given
Yeah.
you some leeway, and we may get to that, but let's focus on whether or not there needs to be a protection order first.
This is definitely true. The context of the hearing matters, and this particular hearing is supposed to determine whether or not an order of protection should be extended. But oftentimes, in fact, from what I hear, all of the time, these judges are able to enter some kind of temporary custody order. So it's not necessarily a bad idea to ask these questions because you don't want to end up stuck with a temporary order that's just unnecessarily restrictive. It's going to happen in some situations, you just won't be able to help it. And I just can't recall what occurs at this hearing with regards to custody. I do believe some kind of temporary order is entered, but I don't know yet because I haven't watched this video all the way through. The other thing I would like to say is you still will have to think about exposing contradictions with regard to your ex's testimony. And in this case, my ex stated, now this part of the video has been skipped past, you'll be able to watch it in the full video, but earlier on my ex had stated that I did not take care of our son very well when she was detained for 72 hours at the mental institute. And so I wanted to contradict that testimony by getting her to admit certain things.
And I neglected to tell both of you this. You don't need this information so much, but you, Mr. Falcone, do. There's water in front of you in case you want to have some. Also, I customarily put out a sheet in a plastic sleeve which shows you what the acts of domestic violence are that this court can base a protection order on. People often confuse why they're here.
I have another question. When we had these arguments and Alex was about to leave, did you ever physically grapple him, physically engage him, physically take his clothes?
Oh, when you were fighting, did you ever try to grab him or his clothes?
Yes. There were times when I got in his way and begged him not to leave, and I did have my hands on him. I wasn't trying to hurt him. He knows that, and he threw me off, and I don't blame him for that because I was in his way.
Did Alex ever physically strike you?
You threw me in, like to hit me, or like when you threw me outside.
You need to clarify the
Did
question.
Alex ever physically punch you, kick you, or slap you?
You never punched me, and I think you slapped me or kicked me once, but you weren't trying to hurt me bad. I don't remember.
So here, she admits the truth, and she does so with hesitation. And the reason she does so, and this is something that happens throughout the entirety of my child custody action, is because she isn't sure if I have some kind of way to counteract her lie. She is very cautious, so she states things in a way that she can back out of them if she needs to. When it came to the punching, she said no. When it came to the other things, she said she didn't know, she can't remember. Now she knows that police officers have shown up. She knows that there are reports, but at this point she doesn't know that this judge is going to decline to review them. And so she admits the truth. And she also states that she doesn't think I was trying to hurt her. So all of these statements that she's making have armored her from being accused as a liar. There's no way to call her a liar. There's no way to say she's committing perjury because she's making statements in a way that gives her an out. And if you watch my video on perjury, it requires criminal intent. There's no criminal intent here when she's saying, no, he didn't punch me. Or, I can't remember, maybe he did, but he wasn't trying to hurt me. There's nothing that a person can do with regards to trying to say they're lying to the court because she's leaving herself so many outs. Now, as I've mentioned in previous videos, this is a terrible way to win a case because most judges will take that testimony as incredible. They will not make findings based on testimony like that. This judge, however, does ultimately do that. And again, I'm going to talk more about that later on in this video. Also, you are about to see me start crying. But here's what I have to say about that. It's not that I'm being subjected to this case and it's giving me anxiety. It's that I can't believe she told the truth. I mean, I had built up in my head that this was going to be a multitude of lies all the way through. And I thought I was going to have a situation where it was going to be her word versus mine. So having heard her say that, I suddenly felt relief. I was like, oh my God, I'm going to win. She just admitted that I didn't do anything to her. That's not ultimately what happens in this case, but that flood of emotion is me in disbelief. Like, it almost felt as though she was changing her mind, that she was going to just back off. So that's what you're going to see here in this case. She cries too in response to me, but I think it's just because she wanted to keep a balance. I mean, in hindsight, having looked back over the course of our relationship, when she showed signs of emotion, now having considered the way that like real people, actual people will show emotion versus how she would, it's missing a certain dimension to it. And so in hindsight, looking back over the years, I'm convinced that when she showed emotion, it wasn't real. It was like the only emotion she could show was anger, and any other emotion was just something that she kind of would mimic. And it's hard to explain to somebody who hasn't gone through one of these relationships. If you have gone through one of these relationships, you can actually tell a fake crier pretty easily going forward in your life. But if you haven't gone through one of them before, it can be tricky to when you haven't seen it or what it looks like. It's just missing a certain piece of it. It doesn't have the ring of truth to it. But anyway, let's go on.
Did Alex ever physically try to remove you?
Yes.
Next question. You need to take a minute, sir.
Did Alex ever verbally threaten to strike you or hurt you?
I don't think so. I don't remember.
No more questions, Your Honor.
All right. Do you have any questions you'd like to ask your client?
Yes, I do. Ms. Farrar, in your statement, you have you've listed that Alex did throw you down the stairs outside your home. Is that correct?
Yes.
Did that in fact occur?
Yes.
I want to pause here because there weren't actually stairs outside our home. We were on the first floor. So I'm curious to see if I expose this contradiction later on. I may or may not, but we lived on a first floor apartment. There weren't any stairs to throw her down.
And as you sit here today in court, Are you still concerned, strike that, that you are frightened and worried that he may stalk you, or that some other act of violence may occur?
And here the attorney is doing her job. The attorney is panicked because all of those allegations of domestic violence having occurred no longer have any substantial basis in reality. The attorney has to switch gears. She's going to plan B now, which is to show the possibility that domestic violence might one day possibly occur. And under the law, a order of protection can be granted if a party shows that domestic violence might occur. So that's why this attorney is changing gears, and she is focusing on the other subsection in the statute, because she realizes that her client has pretty much totally destroyed any hope at showing that domestic violence has occurred at this hearing, not with those admissions that she's made.
Yes.
Nothing further.
All right. Let me ask you some questions, Mr. Falcone. I want you to address briefly why you think the order should be dissolved.
Okay, so this hearing master is making it appear as though she is asking me a question because she wants to know the answer. But she's not. What she's doing is she's speaking to me in plain English with regards to the next part of this evidentiary hearing process, this trial process, and that is oral arguments. And I mentioned earlier in the video that it is very informal, and you may not realize this, but the trial format has occurred. It's just they didn't make it so technical. They had my ex's attorney ask her questions. They had my ex's attorney, they had me ask her questions. I'm curious as to why my ex's attorney hasn't asked me questions, but maybe she didn't need to. The judge at this point is asking me to explain why I think the order should be dissolved. And what she's doing is she's inviting me to now argue. This is what I was talking about earlier in the video. There will eventually come a time when you argue your case. That's where you present arguments that use the facts and evidence that was provided during the prior phase and try to apply those facts and evidence to the law. So what's going on here is I'm going to, argue as to why I think the order should be dissolved, but I am going to make a mistake because this is my opportunity to cite statutory authority and case law, but I don't do that because I don't know that. And so I also focus on this fuzzy idea as to fairness, which is wrong. You don't want to do that when you're presenting your oral argument. You want to focus on the law, and you want to show how the testimony and the evidence supports a particular law to get to the conclusion that you want to get to, in my case, to dissolve the order. And the other mistake that I make is that I focus on my ex's intentions. This is a waste of time. Trying to explain to the court why your ex is doing something usually goes nowhere. You're just guessing. You don't really know why. It's something that you should talk about, but you should really glaze over it. It shouldn't be the primary argument. It shouldn't be what you're primarily focusing on. But I focus on the reasons as to why I think my ex is trying to get this order of protection. And that's not really a basis with which to deny the order of protection. What I have to do is show two things. Number one, domestic violence has not occurred. And I should have discussed that, and maybe I do. I haven't actually watched this part yet, but my understanding, my recollection is that I didn't do that. I didn't focus on the fact that domestic violence hadn't occurred in the sense of citing statutes and referring to her testimony. I just kind of assumed the court would recall the things that she admitted. And the second is to show that domestic violence is not likely to ever occur in this case. And I really should have focused on that. I should have focused on the fact that nothing had occurred in the past, that there were police reports that indicated she was not credible, and that we were no longer together. Domestic violence isn't going to occur if you don't interact anymore. We weren't together. The stuff about stalking isn't supported by anything. She's just asserting it, but it's not true. And so it would have been better for me to focus on the statutes. And of course, not having any idea as to how the law works, I just assumed we were having a dialogue. This is a judge. The judge is asking me a question. I'm going to give her an answer. And based on her subjective perception of what is fair and right and moral, she's going to make a decision. But I've explained this over the course of the years. I learned that this is not at all how the court system works. And so the quicker that you learn it when you're representing yourself, the better, the more effective that you'll be when you actually present your oral arguments.
because she only brought it up when I initiated that I wanted to get custody with my son, and I'm afraid she's trying to make me look like somebody who's bad or would hurt her or anything like that. And it's not true, and I don't want that on there because I never did hurt her and I don't deserve it.
All right. Do you care to say anything in specific about her application or her testimony this morning?
I have to say, this judge is doing a pretty decent job at this point. She is noticing that I presented arguments that weren't consistent with testimony, evidence, or the law, so she gives me another chance. She says, do you want to say something specific to the law and specific to her testimony? Which is good. That's a good judge that is taking that extra step to help a pro se litigant out in a way that they understand.
I have a few things. She says that I threatened to take her out on the phone. That's a lie.
Say that again?
She says that I threatened to take her out on the phone. That's a lie. Also, when she says I threw her down the stairs, I don't know exactly what she means because we lived on the bottom floor of an apartment at the time. We were on the first floor. Our apartment was on the bottom, so I don't know exactly what she means by that. I've never physically struck her. I've just tried to remove her sometimes. She said that she put my suitcase outside and I locked her out. That's not true. She wasn't letting me get dressed, so I went to put her outside so I could get dressed. Then she said that she would let me get dressed, so I let her inside, and she did. I got dressed, I got all of my stuff, and I left.
What do you mean you put her outside?
She was not letting me get my clothes on. We were grappling, so I opened the door and threatened to put her outside so I can put on all my clothes and leave. And then she didn't even get outside. Then she said, okay. And so then I closed the door and she let me get all my stuff and I left.
Okay.
Also, did you get the police reports I filed?
We don't take police reports
Okay.
as exhibits because they typically contain comments and conclusions drawn by other people, so we don't admit those into evidence. You can tell me what you reported to the police.
Okay, so I have a lot to say about this here. This is where the judge royally screws up. But I have to say that there are things that I could have done that would have been better anyway. The reason that the judge royally screwed up is she is referring to hearsay. She is stating that the police reports are hearsay, but she's not using that technical term. And the reason she's saying that is because police reports contain comments by, you have to watch my video hearsay and you'll see what I'm talking about. The gist of it is you can't cross-examine a piece of paper. That's the gist of it. It's an unfair way to win a case because your opponent can't ask questions of a witness who isn't in the courtroom. They can't ask a piece of paper questions. But Nevada has a hearsay exception, and one of my viewers actually sent me the statutes, so I was able to review them. I was going to look it up anyway, but definitely a whole lot of appreciation for this particular viewer. This viewer will be on one of the Viewers Victory videos, by the way. But I have reviewed those statutes, and it is obvious that police reports are a hearsay exception. I'm going to go ahead and put the statute down in the description below so that you can read it. Under certain circumstances, police reports can be used. Now, I did say earlier, though, that I still feel that I could have done more and should have. I think that even if you have a hearsay exception in your state with regards to a certain piece of paper, you should seriously think about calling the witness, the actual person, to come into the courtroom, because even when there is a hearsay exception, the judge can take it with a grain of salt, and this judge here probably would have been one of those judges. So even if I had cited the law at this point, which I didn't know it existed, I just agree with the judge and move on. I figured that the judge is the law, that there is no authority that the judge is bound to follow, because I'm just a self-represented person. I'm ignorant. I don't know any of this. But even if I had cited the statute and told the court there is a hearsay exception, you are required to consider this police report, it is very likely that the judge would have said, okay, I've read it, I have considered it, and having considered it, I don't find it to have occurred. They can do this. They can do this, and this does happen. I talk about this a whole lot more in my video, Standard of Review. The judge can determine the credibility of the witnesses. They can weigh the evidence in any way, that almost any way, not any way. There are certain exceptions to it, but they have very wide latitude. And so even if I had cited the law, it's very likely that she would have just said, you know what, I believe the testimony of the witnesses here in front of me a whole lot more than I believe this piece of paper. And so in hindsight, I do think that despite this judge making this mistake, I should have subpoenaed the police officers. I didn't know that you could even do that at this point. I talk about this in my other videos. But yes, this is something that I should have done. And I didn't do it because I didn't know. So for anyone out there, keep this in mind. Even if you have a hearsay exception in your state, you may need to really think hard about just getting the police officer to come in and testify in court. It sounds way better. It's a much stronger piece of evidence. And then you can have the officer review the report while they're on the stand. So it's a very strong way to put on a case than to just show up in court with a piece of paper. I think one of the things that is frustrating people's understanding of this is the Judge Judy shows and the People's Court. A lot of times litigants bring in a police report and the judge reviews them and gives them a tremendous amount of weight. But that's not what occurs in reality all the time. It depends. I think that Judge Weller gave these reports a whole lot more weight than this specific judge in this courtroom, but that's something that we'll talk about later when I actually get to one of those hearings.
Well, basically, she told them the same thing, but she admitted to them that there was no problem coming back inside, that I did not keep her.
Wait a minute. Well,
I understand what you're saying. I'll keep going. It's okay.
did you hear her say that?
No, I didn't hear her. And I had already left, and she called the cops.
All right.
on me,
Okay.
so-
Go ahead.
So here, the judge is trying to help me again. She is asking me, did I hear my ex say that? And the reason she's asking me that question is because then I can testify as to her having said it. But I didn't. I told the truth. I wasn't there. The police officer was there. The police officer is the one that heard her admit those things. And unfortunately, the police officer is not in the courtroom, and this judge does not want to review the police reports. So that is a huge miss. That's a huge... it's a disappointment, but again, you can only beat yourself up so much when you're not an attorney and you don't have any clue as to what's going on.
When she claims that I went to the VA the second and third time, I did go, but I didn't go by myself. I went with somebody who could serve her, because after she dodged the first one, I was afraid that she might try some trick, like send someone else to get the documents. At that point, I assumed she was trying to avoid service. I just wanted to serve her as soon as possible so I could get the custody for my son. I also want to say that I didn't file for sole custody. I just filed for joint physical because I wanted to spend maybe 3 or 2 days from him. When I spoke with the at the HR at the VA, they said that the stipulations for serving between those times were only for serving VA, like if you had to sue the VA or something. They said when it came to serving an employee, they didn't have any rules. That's what they told me. I just wanted to tell you that. About the suicide, she called me. I had already given all the stuff back. When she called me is when I was looking for a place to stay. And she called me and asked me to take my son shopping. I was suspicious, so I took my son shopping. And she told me to go to 2 places with him. But instead of doing that, I came back after the first one because I had a bad feeling she was going to do something.
Because you had a what?
I had a bad feeling she was going to try something. And when I came back, she had already had all of this stuff. When I came back, it was true. She had attempted suicide, and then I called the police. But I just want to state that I did not drive around with all of her stuff, that I did give back the car scene stuff.
I wanted to pause at this point because I'm actually mingling testimony into my argument. This isn't normally how it works. But because I don't have an attorney, there's nobody to ask me questions. So the only way for me to present testimony without an attorney is for me to what they call narrate. I'm basically narrating my story into the record because I don't have any other way to question myself. Some judges will allow you to ask yourself questions and answer your own questions, but this, from what I have heard, is pretty rare. I think they consider it to be weird. And the other thing I wanted to say is that I do testify as to the fact that there weren't any weird rules, any weird federal rules with regards to how to serve somebody on federal property. But the way that I testified as to that was I used hearsay. I basically stated that Some other person that I asked a question with regards to whether or not there's a procedure told me a certain thing. That's hearsay. I can't do that. But my ex at the same time did it a whole bunch of times when she was presenting testimony. She was stating that she was told there were certain rules, or that she was told she had to file a TPO, stuff like that. So in these types of cases, they're kind of wing it cases. People use hearsay all the time, and the Supreme Court expects the judge to know that they need to disregard the portions of those testimony, of the testimony that's hearsay, and accept the rest of it in the whole decision-making process. So,
she claims that I was irresponsible or didn't want her to be able to take care of my son, and I took the stuff. But at the same time, even when we were broken up, I helped her get a driver's license. I was with her. I gave her I let her use my car and drive and get a driver's license. That's all I want to say.
All right. Now is Ms. Berning's opportunity to ask you some questions.
Mr. Falcone, isn't it true that you did take the car seat away from Ms. Farrar so that she wouldn't be able to and as a result she wasn't able to transport the child, correct?
One of the times when we had a fight, I did take it, but when she called me and told me that I had it, I brought it back.
Isn't it true that you also emptied her bank account so that she didn't have any money to pay for the rent?
No, in fact, we went together, both of us went together to close that account. I did not empty your bank account.
Isn't it true that there was another time that you in fact took money out of the account so that there was not money for her to pay bills to remain in the apartment?
Never.
Isn't it true that during the time that the schedule that you had while you were taking care of your son was that you were basically taking care of your son for the afternoon while he was sleeping, while Ms. Farrar was working?
Yes, while she was working, I took care of my son.
But isn't that true that those were the hours, the afternoon and the evening, and that actually Ms. Farrar took care of your son in the mornings?
Not really. When she woke up, she was tired. I took care of him most of the time. She did occasionally feed him and change his diapers and stuff, but for the most part, I took care of him.
Isn't it true that after the breakup that you required Ms. Farrar to bring all the everything that was necessary for Army, your child, in order for you to have visitation with him?
No, because she would never even let me take him home anyway. She only let me spend time with him at the park.
So you, but wasn't it, didn't you require him to, you never purchased, after you were separated, you never purchased any diapers for him, or you never purchased those kinds of items for him?
She had at one time considered letting me spend some time with him, so I went and bought some food and diapers and stuff. But I never expected her to give me this stuff.
So again, I am pretty impressed with the way that I answered Ms. Berning's questions. I had no understanding of what was effective in the courtroom, but I have mentioned this before. When you testify, you need to give clear, concise, and decisive responses. You do not want to do the Hollywood, well, my recollection, or maybe, or I think about, I could have possibly, no. Watch the way I answer these questions. I respond to them, and that's it. I don't try to argue with the attorney. It's just yes, no, never, always, this occurred, that occurred. It's nothing like the way that my ex testified, which is, oh, it's all fuzzy and I can't quite remember, and that might have happened, and I think, that's not the way you want to testify in court. It will be used against you.
All right, would you like to make some closing comments? And then I'll allow you to do the same thing, sir.
Your Honor, on the basis of NRS 33.108, I believe that it would be appropriate for the court to extend a TPO with the modification that Ms. Farrar has requested to allow visitation for Mr. Falcone. I believe that that the court has heard evidence that the defendant has gone to her work, has done so in an inappropriate fashion, that she testified that there may have been people following her home. She's suspicious of Mr. Falcone. Also the fact that he came to her work at midnight, even if he was going to serve process, that's an inappropriate time to do that. So we really have some elements of a course of conduct that is a conduct of stalking, and that the fact that he's showing up to her work at those hours, and clearly Ms. Farrar has already testified that is very much terrorized her and frightened her. Also, Your Honor, we have the issue of the batteries. Earlier, she testified that the reason she didn't ask for a TPO then is that she was hoping, like any other victim of domestic battery, that it was going to get better. She had deep feelings for Mr. Falcone. She was hoping that it was going to work out. She put his, and so because the police had responded to this situation, she was advised she could get a TPO. She decided not to do that because she was trying to work things out. That's not unlike many of the domestic violence victims that this court sees. Your Honor, I believe as she's testified in court today, she is fearful of Mr. Falcone in a deep sense, that she wants to make sure that that he does have access to his son, that the purpose of this petition, that her motion before the court for extension of TPO is not to preclude him in any way from his son, but to give her the protection that she wants to have both at her work and at her home, with the modification that he's able to see his son and that they can have telephone contact in order for her to be able to assist him if he needs that assistance with the son. I believe, Your Honor, with the modifications, it would be reasonable to extend the TPO, and that the basis pursuant to NRS 33.018 do in fact exist in the areas of battery and stalking.
As you can see here, the lawyer does her job again. She's presenting her oral argument, she's closing up, and she is referencing the testimony of both of us. She is referencing some generic information as to victims of domestic violence. It is actually true that some victims of domestic violence who are actually victims will testify on the stand contrary to their own allegations prior, out of fear for their abuser. So for her to use that, it's a smart tactic, because it's true, that does happen sometimes. And she cites the statute at the very end, which it's what you're supposed to do. So then let's take a look at my closing arguments and see what I do.
Thank you. Sir?
Yes. I've never hurt her or threatened to hurt her. The only time I ever even went to approach her was when I had to serve her with these documents. Never before, never after. I've never physically followed her home or done anything like that. Once I served the documents, that was it. I didn't ever chase her around or call her or do any of these stalking things. I have no interest in stalking her. I left her. It was hard, but I left her. And it was not like, I have no intention of stalking her or hurting her, Your Honor. I'm sorry.
That's all right.
And so this is a complete misuse of closing arguments. I didn't reference a testimony. I just reiterated what I had already said before. I didn't cite any statutes, rules, or case law. It's actually better in a formal court proceeding to cite statutes, rules, and case law in the briefs and maybe reference them during closing arguments rather than cite specific codes and subsections and stuff like that. But as I mentioned prior, when it comes to these order of protection actions, it's very much a wing it type of court proceeding. Very little difference from just like a small claims case where you just walk in and start talking. So in many ways, you really have very limited options with respect to what papers you're going to reference. But I don't think that it would have made a difference. Had I cited statutes, rules, and case law and referenced a testimony, I still think the judge in this case was going to make the same decision that she does ultimately make in this case. And had I brought two police officers, the ones that were the officers that prepared the reports, I am still very hesitant to think that this judge would have ruled any differently. And this is because, let's wait till I get into a ruling and I'm going to explain some of what I think goes into the thought process. The only thing that I think would have made a difference is that I had hired an attorney, but not because there was anything else that I could have done. It's for the reasons that I'm going to go ahead and talk about later when we get towards the actual ruling. I'm going to talk about this, what I think the basis of this judge's decision is made on in a second.
Thank you. I'm looking at this in the big picture because I know you have a custody case, which is where you need to get those long-term decisions addressed. I can't really base anything on your suspicion that he's stalking you without more. I mean, I need more factual background for that. And it's not there, perhaps because it's only a suspicion on your part. And the work thing seems to me to be, on one side, to be some confusion about what the rules are. He apparently was told that a VA employee is different from trying to serve the VA itself. But it also strikes me, on the other hand, that midnight is an awfully odd time to try to serve someone. Sir, no, this is my turn. But I'm looking back at the testimony earlier about the earlier events, and you strike me, sir, as a fairly conscientious, serious person. But you also strike me as a young man who really doesn't quite understand all of the consequences of his behavior. In other words, the effect they have on others. I know that you have issues with custody, and I believe that both of you care deeply about this child. What I'm concerned about is during this period where you're trying to resolve your differences, and I'm sure you will, it's a dangerous period. And I don't quite believe you that you've never touched her, never done anything else. She gives a pretty vivid description of what happened, and I believe that there was some pushing and pulling at one point, because the two of you couldn't quite decide at that point what kind of relationship you were going to have. You know, stay, don't stay, you know, I'm leaving, no you're not, and so forth. But there was more here than that. So based on what I think was a reasonable fear, and I don't think she made this up about the threat. I don't think she made that up. You may not have realized the impact a statement like that has, but it can be pretty profound, given the nature of your relationship. You may never have intended to do anything, but you said it, and it's terrifying. So I'm going to extend the order for 3 months only, based on this course of conduct that I believe there was a battery, and I also believe that you made that kind of a threat. And in the context of this kind of a case, there is a reasonable fear that something more might happen. I hope not. I want you to prove me wrong.
So I very much did end up proving this judge wrong. Ultimately, my ex's parental rights were terminated for serious abuse and neglect, specifically physical abuse on the child. She did ultimately use this decision to obtain a fictitious address to hide from 6 different CPS reports that other people had filed on her that I didn't. And 8 years down the road, this so-called victim of domestic violence no longer is a parent in the eyes of the government. A termination of parental rights is the most serious response that a court can take against a parent. It's tantamount to a civil death sentence. And there are a whole lot of things I want to talk about with this decision. I don't think that she honestly believed that my ex was in any danger. But I do think that she made this decision because she wanted my ex, who had hired an attorney, to walk away with at least some kind of small victory. This is the video that led to me creating the video, Overcoming Lies, Moving Forward. This is something that happens in a lot of these cases. A parent will have no attorney, and the other parent will. And the judge, rather than feel bad for the parent who lacks an attorney, feels bad for the parent who has an attorney, because that parent has paid multiple thousands of dollars towards that attorney. And having been an attorney themselves, it looks really bad when their client hires them and they walk away with nothing. This judge makes a finding that I actually made a threat, but I don't believe that the judge actually thought that. I believe that she needed to make some kind of finding to support her decision in this case. And had she not made that finding, there would not have been anything there. So this leads me into the next discussion, which is another one of the most serious discussions that I can have with my viewers. We can twist the court's arm on the law. I learned this over and over again as I filed appeal after appeal, and I won 4 different appeals. But it is very difficult for us to fight the court on their findings of fact. And this is because the appellate courts defer to the lower courts on their findings of fact. It doesn't actually matter what you truly have or have not done. If there is some kind of evidence, what they call substantial evidence, to support a finding of fact, and the court makes that finding, whether or not it's true, as far as the appellate courts, as far as the record is concerned, it's true, even if it didn't happen. And that's why I did that video, Overcoming Lies Moving Forward, because when a finding like this is made, and there is testimony to support it, which there was my ex's testimony, you're screwed. That's it. That's the finding of the court. So the only way that you can beat that is to move forward and to raise different allegations and to prove your case in other areas, like I was able to do with proving child abuse, child neglect, dental neglect, and almost proved educational neglect. I was able to overcome this lie by proving a multitude of more important truths. It's a weird way to speak to ordinary people, but in the eyes of the law, this is how the truth works to them. A judge listens to testimony, reviews the evidence, makes findings of fact, and that's the truth. There's nothing that you can do later on to disturb those findings of fact, with rare exceptions. If you want to, you can take a look at my video, Standard of Review. I clung to this for a while, and it wasn't too long. It was maybe for like a year, and it wasn't constructive because you can't go back and fix problems like this. Not findings of fact. If it was an error of law, I could have fought it, but it was an error of fact. And unless there is no evidence at all to support it, there's nothing you can do. Some people will say, yeah, but she changed her mind later on. You know, there is something called impeaching the witness. You can try and do that when they go back and forth and contradict themselves, but I don't think there was enough here to contradict her, because as Kathy Berning raised, it is common for domestic violence victims to waffle. And so if I had brought that to the Supreme Court, it's likely that they would have said, oh, well, maybe she just was scared or something like that. And besides, this judge doesn't make any findings that I committed any stalking, nor does this judge make any findings that I committed any battery. The only finding this judge makes is that I had threatened her. And she kind of makes it seem like she understands our relationship. You know what? These are canned statements that these judges make. They don't know you. They don't know your ex. But they will say things like this to kind of allude to the fact that they sort of have a gist as to what happened. In reality, they regurgitate these statements to every case that comes before them. They'll say things like, oh yeah, you guys got in a fight, you didn't know where your relationship was going, I think this happened. And they try to make it seem like a personal thing, like they attach it to you, but it's really not. It's very impersonal. And this is something that I learned probably around year 3 or 4, is you just have to sort of disregard all the nonsense that the judges throw in there and focus on their findings of fact, their conclusions of law, and their order. You focus on the findings, the conclusions, the order, and you move forward. When it comes to a high conflict child custody case, it's not over until it's really over many, many years later. So you just need to stay focused on your next hearing, on how you're going to approach the next allegations that arise, and on how you're going to try to control the court to the extent that you possibly can. So let's continue. I don't think there is a whole lot more with regards to this judge's conclusions. You do notice that she extends it for just 3 months, not a year. But there may be something else to listen to, so I'm going to go ahead and continue.
So I'm only going to extend the order for 3 months. I'm not going to grant it for a year. I don't think it's really necessary in this case. So, and we're going to talk a little bit about the visitation issues and so forth. And sir, if you disagree with my decision today, you have 10 days from today to file what's called an objection, all right?
This part here where the master lets me know about the objection process, it's nice, and to be honest, there are many worse judges out there who won't mention anything like that. There was even once a judge who told me that I didn't have the right to appeal, and he almost laughed when he said it. That was the one judge in my 8 years of representing myself that I reported to the Commission on Judicial Ethics, and that the Commission on Judicial Discipline, and that was investigated. It was pretty serious because it got to not phase 3, which is prosecution, but it got to phase 2. But anyway, this judge is letting me know about the procedure. Would it have mattered? Honestly, no. If I would have filed an objection to master's recommendation, but by the way, definitely watch my video on that, because I explain how it works, and it's crucial that you understand this, because some people might file an appeal from this decision, and you cannot appeal this decision. You first must object to the master's recommendation, and then if the judge sustains that the decision, the recommendation, and they enter an order, then you file an appeal from the judge themselves, not from the master. But it would have been futile for me to try to file an objection to it, because first off, I didn't know how the law worked. So I would have just reiterated what I had already said, and the district judge would have just said that this is not an opportunity to have a redo. So they would have affirmed on that basis. But had I even known what the law was and challenged it, the district judge would have just stated that substantial evidence supports the decision. And many people don't know what substantial evidence is. If you don't know what that is, watch the video standard of review, because it's not what you think. Substantial evidence is just any shred of evidence that a reasonable person might decide supports a conclusion. It does not factor in weighing evidence. So you can't say that I had better evidence than them. You cannot do that. It also does not allow you to reweigh the credibility of the witnesses. So if you have more witnesses, or if you have more credible witnesses in your eyes, you can't do that. You cannot disturb the findings of fact by asking the next judge or the appellate court to reweigh the credibility of the witnesses. These are things that are etched, that are locked in, that you are just stuck with. And again, this is one of the, in my opinions, weak areas of the legal system, because it allows judges that might not really understand the consequences of their decisions to make mistakes on their finding of facts that have profound consequences going forward. And as I've mentioned in this video multiple times, I do believe that had this order of protection been denied, my ex would have abandoned all of these claims, and I do believe that I would have never had grounds to seek a Supreme Court publication. And to this day, there may not be a procedure in place to challenge the Secretary of State's confidential address program. So this small kindness, which I think this domestic master afforded to my ex, ended up having profound consequences, not just for my ex, but for all of the victims in this state. So I'm not sure that anyone really could have predicted how much this would have snowballed.
Okay. Let's talk about the protection order. Sir, for the next 3 months, you are prohibited, directly or through others, from threatening, physically injuring, or harassing the applicant, minor child, and you can't sell, damage, destroy, give away, dispose of, or tamper with property she owns or property in which she has an interest. You can't have any contact with her, directly or through others, except through Miss Berning, all right, or in a courtroom situation such as this. That means in person, by phone, mail, email, fax, or otherwise, unless we make an exception, and I think we're going to do that here in a moment, all right? You'll have to stay 100 yards away from her confidential residence. 100 yards is a football field from goalpost to goalpost at all times, whether she's there or not. You understand? You will continue to have temporary custody based on this emergency motion until there's further order in the custody case, which is FB 08-03200. You've got that? You'll have to stay 100 yards away from the school or daycare, and 100 yards away from the VA hospital at 1100 Locust Avenue. You don't have any need to go there, do you?
No.
Okay. Now let's talk about, do you want telephone contact or email contact, or both? You know what? Let me just stop you right here. Stop for a moment. You are both young parents. Neither of you are going to wholly approve of what the other parent does. But you've got 16 more years to figure this out. And you are going to have to trust a little bit. You are both going to have probably other relationships. There are going to be other family members involved in this child's life. Nothing is going to be exactly the way you want it. This is about compromise and putting the child's best interest first. So, I don't want to hear a lot of bickering about what you've already discussed. We're here to try to find a solution. Now, is there anybody else who might be willing to do this? And do you need to contact this person? Through October 24th. Thereafter, the adverse party shall have visitation.
Thursday from,
Can you have it till midnight when I get off of work?
no.
Oh,
Your Honor, may I speak with my client
Sure.
for just a minute?
because how's he gonna care for before we can get? No, she absolutely does not want me to know where she lives.
She's gonna have to get over that.
Going to happen. So I propose that we just leave it this way for the rest of the time of this order, unless and until the judge in your custody case says, oh, let's make it some more or less, whatever the case is. What do you think about that, Mr. Falcone?
Oh, that sounds fine.
All right. Otherwise, you're going to be back in here, and I'm going to be negotiating your custody case.
So you'll see that I glazed over the last few portions of that video. I showed a few highlights as to what some of my viewers can expect if they do decide to click on the link in the description below and watch the full unedited video. But for the most part, it is the judge or the domestic master setting up temporary visitation orders because she wants to make sure that we have at least something in place that's going to tide us over until we get to the presiding district judge in the child custody action. There were a few occasions where my ex's attorney reined her in when she was making certain requests as to when we were going to exchange the child. It was like at midnight that she wanted to do it. The other thing that I wanted to mention is the supervised visits. When they're set up like that and there's a trigger for them to end, it's not so bad to agree to it. In my case, the domestic master ordered the supervised visits for 2 weeks only, and then automatically, without even having to go back to court, those would end, and I would resume unsupervised visits with much more substantial time. I don't see a problem with agreeing to this. I think it's kind of unfair. Apparently this is something that they did back in 2008. Anytime a mother specifically accused a father of being dangerous, the court would fall back on supervised visits, at least for a little while, to just make sure everything was okay. This is the stuff that, I talk about this in the video, gender bias. I also talk about it in the video, discretion. It's getting better and better as we continue into the future. But it's not so much because the judges are becoming any wiser. It's just because the legislature is passing statutes that force the judges to do certain things that they wouldn't ordinarily do. They're closing these gaps. They're shutting down these areas where the judges used to have wide latitude, and they're making things a lot more strict than they used to be. And so over the years, at least in Nevada, some of these practices that the judges would engage in aren't they aren't the norm anymore, but back then it was. So I would be hesitant to tell people it's okay to agree to supervised visits nowadays, especially if there's no basis. And also, if you were going to agree to anything like that, make sure there's a trigger for it to end without having to return to court, so that you just know that after a couple of weeks, 3 weeks, maybe a month at most, you'll be able to have unsupervised visits with your child. The third party supervisor that I agreed to, I feel like that was a little risky. If you're in a high conflict case, especially if your ex has a personality disorder, if they have a personality disorder or they have severe emotional immaturity issues, be warned that they may take advantage of the fact that you have those supervised visits for a short little while to try and get that witness to try and get that third party supervisor to be a witness in the case going forward, to try to have them maybe snoop around in your house or maybe just outright lie. I mean, it didn't happen to me in my case, but it is something that I would warn people about going forward. If you have a high conflict ex, they may take advantage of that process, of that supervised visit process, to try and create more evidence out of thin air. This is something that they go about doing because when you have false accusations, they won't go very far, at least not for a very substantial amount of time. They may make a judge nervous initially. But if nothing is happening, eventually the court's going to say, there's nothing to what you're saying, ma'am. Or if the false accuser is a man, they'll say, sir. But I think that being said, we can go into the aftermath. My ex and I would not have incurred any costs in going to this evidentiary hearing on the extended order of protection. I didn't have an attorney, so I didn't incur any attorney's fees. My ex had an attorney, as I mentioned previously. We're going to go with the rate of $250 an hour. This hearing lasted about a little over an hour, and I'm sure that the judge would probably charge her for the costs, or sorry, charge her for the time to transport to and from the hearing. What I mean is to drive to the courthouse and back. And there was probably a little bit of waiting time in the waiting room. So I'm going to say that she probably charged for 2.5 hours, which would amount to $625 in attorney's fees. So that is going to wrap up this video. Again, if anyone has any questions or comments, go ahead and post them in the comments below if it pertains to part 8. And if it pertains to the unlisted video, go ahead and post those comments in that video specifically. It's a better way for me to organize where to respond to questions. So I will definitely be looking forward to part 9, and I will see you guys next time.